Well, hello everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, and we are here with our continuing coverage of the case of 7M versus Katie Joy Paulson and Without a Crystal Ball. Katie Joy Paulson is a person who has a successful YouTube channel and has been sued many times. We have covered many of her lawsuits, and pretty much all these lawsuits so far have been total crap. None of them work. Like, even a little bit, like at all. They are all really, really dumb. But 7M was the exception to this pattern of dumbness, where 7M seemed like, well, no, maybe you do actually have a case. Because Katie Joy Paulson said some very aggressive things when it came to 7M. 7M is a talent management agency. They represent influencers and others, dancers and whatever, and try to get them work in various contexts, or at least they did, because I'm not 100% sure if they're still in business or not. But at one time, they were a company that managed talent. Katie Joy Paulson over here said some very aggressive things about 7M, which we have gone through in the complaints in their various manifestations. Paraphrasing and not quoting exactly, Katie Joy Paulson had essentially said that 7M had engaged in human trafficking and basically forcing people to work for them and stole their money and, was a very, very bad talent management company, or engaged in some shady practices, possibly illegal practices. And she made many statements, as we've gone through in prior filings, which went on for many pages of very specific filings, and these were very problematic. At least it seemed. And so this lawsuit looked like it might have potential. When we last left the action, she had lost her motion for summary judgment because, well, her response was basically non-existent legally in terms of the motion for summary judgment, so denied. And it looked like she had missed a deadline with respect to some discovery issues. And 7M had moved to default. And we are picking up the story with what the court ordered. So let's just go ahead and do that. We are in state court in the great state of Minnesota, the county of Wright. 7M Films, Robert Shin, who is its CEO, and also incidentally pastor of a church, which led to Katie Joy Paulson saying that the company was a cult and other things like that. So there was all that and some other people versus Katie Joy Paulson, aka Katie Joy, aka Without a Crystal Ball. All right. So the honorable matter came before hearing on the parties' motions on November 21st. It's been a hot minute. This is all relation to a hearing that was held 3 months ago, and we're just getting around to issuing an order about it now. So why that's true, one could imagine many reasons, but it's true. Due to COVID-19, the matter was held remotely via Zoom. All parties could be heard. Based upon the reports, filings, and arguments herein, and after being fully advised, the court makes the following rulings. It is hereby ordered that plaintiff's motion for default judgment is denied. So whatever discovery problems Katie Joy Paulson may have, well, it's not going to result in her just losing. There was certainly a possibility under the rules, but the judge did not order that remedy. The plaintiff's motion for temporary injunction is denied. They wanted her to stop saying things. Apparently, we're not going to do that. Plaintiff's motion for amended scheduling order is granted. We're going to revise the scheduling because, well, we were supposed to go to trial, I think, in April, and that's obviously not going to happen. So we need some revision. So now we have a new deadline for service of discovery process and filings of all pleadings on May the 31st, 2023. So we are going to basically reopen the case, essentially, in so many words. We are giving a new deadline for discovery requests and filings of pleadings. So we are allowing them to amend their pleadings if they need to, basically do whatever they need to do, file brand new discovery requests by May 31st. Deadline for joinder of additional parties, which we pursuant to discovery, presumably, would be June the 30th. So not that long thereafter. The parties shall provide a written designation of selection neutral to the court for a mediation process. The court wants these parties to see if they can agree through a mediator. So fine. Non-dispositive motions shall be served and filed not later than September 29th. Dispositive motions filed not later than October 31st, and a pretrial conference held on October the 31st. Defendant's motion to compel discovery is denied as premature because we just reset all the deadlines. So your request to compel discovery did make sense, but now it doesn't make sense because I just reset all the deadlines. So now it doesn't make sense because discovery is not due yet. The motion for protective order is granted in part, so we will get some sort of protective order out of this. We'll read that. So I guess I misspoke on the whole, not an injunction thing. So we'll see what the protective order is. The terms of the protective order will be set out separately. The attached memorandum is attached here too. Okay, so what we've learned so far in this is that the court, for whatever its reasons are, has decided to basically reset everything. It's like reset everything and give all the parties another chance. And this could be due to a lot of reasons, not the least of which is the court's own needs and the court's own sense of fairness. Courts don't tend to like to order default. They don't tend to like to order that the party just loses. If they seem to be participating and seem to be moving the things forward, they seem to be prosecuting the case, as we sometimes use that phraseology to put forward the case. As long as they're both kind of participating, the court is very unlikely to order a default judgment as an initial remedy. It's an extreme remedy because it's how about you just lose the case. And so this is not particularly surprising. I think under the relevant rules, the judge certainly could have ordered default, but it is not atypical that judges will not do this. And I think I've spoken to this issue many times before. This is definitely one of those things where the temperament of the judge is something that really controls. Some judges are much more rule-based and are like, if you miss a deadline, I'm just going to destroy you because, well, it makes my life easier. One less thing for me to decide. I'll go to someone else who plays by the rules. But it is not uncommon to find judges who will be a lot more lenient on the rules and want to avoid default judgments. So while I think this could have gone the other way, this judge sees things a particular way, and it is a matter of judgment, so fine. All right, so let's go through the background posture as the judge tries to rationalize their own action, which makes sense, right? We want to see if this order makes sense. We can track the judge's reasoning. We can see if it makes sense. All right, so on March the 31st of 2022, 7M Films, the production company / talent management agency / whatever, and Robert Shin, which are a talent management company and CEO and sole owner, based in California, commenced this lawsuit against Katie Joy and Without a Crystal Ball, a Minnesota resident and Minnesota corporation. Ms. Paulson runs several social media accounts with substantial reach. At least as of the time of this video, she has 320,000 subscribers on YouTube, so seems to be doing something right out there. So, good, I suppose. I don't begrudge anyone their success. I wish I had more success of my own, but if people like her, then, fair enough. Numbering in the tens or hundreds of thousands of followers and attendant engagement, particularly on Instagram and YouTube. The complaint was amended just days later, adding Miranda and James Derrick, husband and wife and associates of Shim. The amended complaint does 9 causes of action against Ms. Paulson, but counts 1 and 2, defamation per se, ultimately underlie the remaining counts. This is very typical in a defamation action. It is very typical that the defamation controls pretty much everything. And you'll get associated things like tortious interference or false light or things like that. But it is not uncommon at all that everything sort of rises and falls with the defamation. Again, it's not universally true. It's just common. So the judge's analysis there makes a lot of sense. Plaintiffs allege that Paulson, via Instagram page and other social media, defames plaintiffs by posting statements about 7M and associated individuals. The plaintiff's business is in the field of social media communications and marketing, as well as brokering deals between performers, particularly dancers and commercial venues, as I described. 7M is a talent management agency. They represent, TikTokers and YouTubers and Instagrammers and dancers and so forth and so on. Defendant in her social media posts claims that plaintiff, in addition to the commercial ventures, are involved with the Shekinah Church, which plaintiff claims the defendant characterizes as a cult. Shin is both CEO of the talent management company and pastor of the church, but that doesn't in and of itself mean the two are tied, because a person can have two unrelated businesses. So it might be suggestive in some ways, but doesn't necessarily mean there's a tie between two different businesses. Plaintiffs claim that the defendants have acquired and published court documents from litigation involving plaintiffs, which were subject to a protective order, as well as defendants claiming that plaintiffs engaged in criminal conduct, including human trafficking, waterboarding, and kidnapping. As I mentioned sort of in my prologue, that Katie Joy has broadly accused 7M of human trafficking, basically indentured servitude, stealing wages, kidnapping, all kinds of nastiness. Katie Joyce Paulson, at times, her language has been quite aggressive. Again, if you want more detail about exactly her language, then you can go back to earlier videos where we go through the complaint and we look at some of the exact language. It was somewhat intense. That doesn't necessarily, of course, mean it's defamatory, because it could all be true, but it was a lot. It got my attention. Plaintiff's other claims are rooted in the same allegedly defamatory conduct by defendant, but pled as tortious interference, intentional interference with prospective advantage, which is tortious interference, deceptive trade practice, negligence, and intentional infliction of emotional distress. And kind of no surprise that the court just says, it's all defamation. Defendants brought a motion seeking dismissal of plaintiff's complaint for failure to state a claim. No, it states a claim. On August the 26th, plaintiff brought motion seeking temporary injunction against defendants. Continue posting about the incident manner on social media, or in the alternative, for disclaimer on each post, there's an active defamatory suit ongoing, for a protective discovery order, and for amended scheduling order to extend the timeline for discovery. So one of the things is that there's been this protective order, and this is one of the reasons that Katie Joy said that she didn't have to respond, was because that there was this protective order out there. My particular reading of the Minnesota rules, and the court will, I'm certain, correct me if I'm wrong, we all learn. I'm not a Minnesota lawyer. The Minnesota judge may school me. If he does, then fine. We all learn and become smarter, right? But my reading of the rule didn't seem to allow for this. But except maybe in sort of an equitable fashion, the rules on their own terms didn't allow for this. It seemed like Katie Joy Paulson had to respond, notwithstanding the pending protective order, but maybe the court's like, no harm, no foul, and reset. So I think a strict reading of the rules might imply one thing, but the court, in sort of applying its own sense of equity, is doing a slightly different thing because it seems fair to the parties. And as I mentioned, a lot of judges don't like default remedies anyway. So, and if the judge feels like there's been a good faith effort on Katie Joy Paulson's side to perform and prosecute the case and respond to things, then the judge is likely to grant this sort of relief. Again, your mileage may vary if you find a judge who's particularly rule conscious, but this is not atypical. Okay. On October the 4th of 2022, the plaintiffs brought motion seeking default judgment on the basis they didn't file an answer within 14 days of the court order denying defendant's motion to dismiss. So yeah, filing an answer. I said filing discovery, but they didn't file an answer. So that's why, right? Because, so I misspoke and I have to correct myself. Earlier in the video, I said this was a discovery issue. It wasn't. The court is correct. It was not filing answer. That was correct. So I made a mistake, and I correct the record as we go, right? So the problem was she didn't file an answer. The reason that I didn't think that her failure to file an answer was excused is because an answer is just a formal response to the accusations. If you need more information to respond because you don't have it in discovery, you can just simply say, I don't have enough information to respond, right? The answer is just a response to the complaint. The complaint sets out, here's a whole bunch of accusations. Do you agree or do you disagree? And you can respond by saying, I agree, I disagree, or I don't have enough information to give a response. And so one of the reasons I thought that she didn't really have a reason to not file the answer was because if she really felt like she needed more information to respond, that in and of itself is a valid response. But she never filed the answer, right? She never filed the answer. And she's like, well, I'm waiting for this thing to give an answer. But strictly speaking, she doesn't have to wait, because she could just be like, I don't know, because I'm still waiting and I don't know the answer. If you don't know the answer, you don't know the answer. That is a valid answer, if it's true. So that's one of the reasons I thought that maybe this didn't really quite work. So anyways, they brought a motion seeking default on the basis that they failed to file the answer, the formal response to the did you do it? And she didn't file it. On October 31st, defendant filed a motion to compel discovery seeking an order that plans to provide an immediate response to defendant's first set of interrogatories and documents along with attorney's fees. So again, this is one of the reasons that she said that she didn't have to provide the answer, because I didn't get the discovery I'm entitled to. And so I can't respond with the answer, which doesn't seem like strictly speaking correct, but we'll press on. All right. The rules of civil procedure provide that a defendant shall serve an answer within 21 days after service of the summons upon the defendant. However, if defendant elects to respond to a summons served upon them via Rule 12, a response of pleading to summons and complaint shall be served within 14 days after service of court action. So basically, you can file an answer within 14 days, or you can file a motion to dismiss within 14 days. And once the court rules on that, you have 14 days from then to file the answer. And the court did deny, quite properly, the motion to dismiss because there's a prima facie case. And, go forth. The rule concerning default judgment provides that when a party against whom a judgment for alternative relief is sought and has failed to plead or otherwise defend within the time allowed therefore by the rules, and this fact is made to appear by an affidavit, judgment by default shall be entered against the party. The court may deny a motion for default judgment if the defendant has a reasonable defense on the merits, defendant has a reasonable excuse for failure to answer, defendant acted with due diligence after notice of the entry of judgment, and no substantial prejudice will result. All four factors must be satisfied. So now you're just into, are all four factors satisfied? And this is where you get a judgment call. Does defendant have a reasonable defense on the merits? Possibly, as to at least some of it, yes. I think Katie Joy Paulson has a reasonable defense on some of the merits. I don't know if she has a reasonable defense on all the merits. There's a lot of stuff. But I think a fair amount of it could be viewed properly as opinion. And to the extent that Katie Joy Paulson has external things that she would be reasonably relying on to form the basis of her purported facts, then she may very well not be negligent or reckless, as the case may be. Although I don't think reckless is the required standard, because I don't think 7M nor Shin is a public figure. Although you could try matter of public concern, but it seemed a little thin. Negligence seems like the correct standard, but even if negligence is the correct standard, it doesn't mean that she was negligent even if she was wrong. Right? Negligence doesn't mean that you were correct. Otherwise, it would just fold into truth. Truth is a separate thing, right? The truth or falsity is a separate thing from negligence. So something can be false and not negligent at the same time. It must be true. Otherwise, they wouldn't be separate elements. So it might be the possibility that there are things that she could rely on reasonably that might form the basis of what she said. So she might have reasonable defenses as to at least some of it. Does she have a reasonable excuse for failure to answer? I don't know about that one, to be quite honest, but the court will assess. Defendant acted with due diligence after notice of entry default judgment. That much, I think, is true. She gave her answer very, very promptly after that. And no substantial prejudice. Again, debatable. But she's got at least 2 of the 4 factors. And then it's a question of, can she get the other 2? All right, let's find out. In this matter, it is undisputed that the defendant did not timely file an answer to plaintiff's complaint. Notice of the court's filing of order denying defendant's motion to dismiss was e-service upon parties' counsel on August 25th of 2022. Accordingly, defendant's answer would have been due on September 8th, and no answer was filed. However, by conduct in this matter, defendants have clearly pled or otherwise defended the action within the meaning of the rules. Analyzing the factors set out in the law, the court finds the defendant meets all these factors. As discussed above, despite plaintiff's complaint pleading 9 separate counts, the heart of the matter is 1 and 2, which is defamation. To prove defamation, plaintiff must prove the statement was false, communicated to someone other than plaintiff, it tended to harm the plaintiff and lower them or esteem, and also at least negligence, presumably. In this matter, by their conduct and by the nature of the plaintiff, plaintiffs are almost certainly public figures. I don't know if I agree with that conclusion, court. I don't know if I agree with that conclusion, that plaintiffs are almost certainly public figures. I'm not sure if that's quite true. Plaintiff is the company, 7M, is a talent management agency. Their goal as a company is to get the talent they represent to have work. So they're certainly thrusting their clients, by their clients' consent, presumably, but they're certainly thrusting their clients into the public space. That isn't quite the same thing as the company themselves being public or public facing, right? There are companies out there that are quite private. And even if what they do as a company is somewhat public facing. There are companies out there that are just media shy, if you like a simple example. There are companies out there that just kind of go below the radar. Major companies in some ways, companies you've never even heard of, companies that do very major things and are known to people potentially in the trade, but not known to the public at large. They keep a quiet presence, even as they, as a company, make substantially large impacts in the world. So I don't know if I quite buy this analysis that they're almost certainly a public figure. Robert Shin seems like an incredibly private person. Finding an image of him online is like borderline impossible. We found there was one attached to the complaint, but he doesn't seem to be going out of his way to be public. And his church doesn't seem to be public in this sense, right? It is not making a show of itself. It is a private church, and in a lot of respects, I don't know how else to put it, right? Robert Shin seems to be like an incredibly private person, and his church seems to be very private. 7M as a company, I've certainly never heard of them. That doesn't mean that they aren't good at their jobs, but I don't know that it's quite correct to say that 7M is a public figure, almost certainly public. But that's my view of the thing going on. Let's see if the court can convince me otherwise. Furthermore, defendants are plausibly a journalistic outlet which enjoys qualified privilege against defamation claims. Fair enough, right? Is Katie Joy Paulson a journalist? She very well may be under relevant law. So, and, possibly it has to be assessed further. I think that's fair. Accordingly, they find the defense have reasonable substantial deference on the merits. I will take note here that the court simply says the plaintiffs are almost certainly public figures with no analysis, which is frustrating to me personally, because I'm always happy to be proven wrong, right? I could be wrong, and the court says something, I'm like, okay, well, I could say a lot of things. Like I could just say I disagree with it flat out, as I often do, or I could say, well, that's one way of looking at it. I'd look at it this way, or I'd say, oh, the court convinces me this is actually the superior way of looking at it. I changed my mind. But unfortunately, for me personally, the court does no analysis as to whether or not 7M is public. They just say it's almost certainly true. Conclusory. Well, that's a disappointment in my day. But pressing on. He's an author and has published multiple books. Okay. Robert Shin is a published author. I don't know if that makes him a public figure or not. I guess it does make him more a public figure. So if it is that she has lots of books, if it's that Robert Shin has lots of books and he's published a lot, I mean, that certainly injects him much more into the public space than the church thing. If he's published, and that's closer for sure. So if that's the basis, then maybe. So if that's what the court is thinking, then maybe. With respect to the second factor, defendants have a reasonable excuse for failure to answer. Defendants argue they were anticipating further order from the court, given the deadline to file an answer following the court's denial of motion to dismiss. While such an order may be customary, the rule itself provides clear instructions. However, a defendant also argues they are taken away from the office in September 2022 due to family emergency, which the court finds as a reasonable excuse. Fair enough. Fair enough. Court wants to grant you mercy. Fine. Moreover, from a correspondence between counsel supplied affidavits, clear the court the parties were engaged in active communication concerning the matter in the time period in which defendant's answer was due, evincing intent to continue to defend and participate. The court finds they have reasonable excuse. Fine. Fine. You know, again, this is like if I would disagree personally, fine, but the court's analysis also makes sense. With respect to the third factor, the court finds defendant acted with due diligence filing notice. I agree with that. Plaintiff filed their motion for default on October the 4th. The very next day, defendant filed an answer. A gap of a single day is clearly sufficient. That much is true. Finally, if the court finds the plaintiff would not be prejudiced by failure to grant default, the gap between when defendant's answer was due pursuant to the rule and when it was filed was 27 days. In this time, as discussed above, the parties were communicating. Furthermore, by the time a defendant's filing answer, plaintiff had motion seeking temporary injunction, protective order, and amended scheduling order, which would strongly indicate that the court plaintiffs intended to continue litigating without respect to defendant's failure to answer because they made a showing. Yeah. All right. So basically, it's too small a time gap to matter. You know, it was supposed to be 14 days. In reality, it was 27 days. Close enough is basically the court's analysis. And even if I disagreed about the public figure thing, which I do, I don't need that to agree with the first element of the court's analysis. Because even if they're not a public figure, Katie Joy Paulson may have defenses using the negligence standard. So them having the elevated standard of public figure would certainly be helpful to Katie Joy Paulson, but it's not required. So, you know, fair enough. They certainly filed it very timely once they were notified about it. They did say that there was some sort of family emergency in there that escaped their attention. They were in communication. They seemed like they're acting diligently. Let bygones be bygones. This is not atypical in any way. I wish to emphasize this point. This is not atypical in any way. Again, some courts are going to be harder about this than other courts, but it is not atypical, particularly where the court feels that they have been prosecuting or defending the case in a vigorous way. So, all those good stuff. You couldn't find any books written by Shin? Yeah, I don't know anything about books written by Shin. This is new information to me. I don't remember that coming up at any point in the filings. So I don't remember anything about him being anything about a published author. I don't remember that. So I'm back to, but it's not, I don't need it to agree with the court's analysis. It's a nice to have, but it's not required. Right? I can disagree that they are a presumptively public figure and still completely agree with the rest of it. Because whether or not they're a public figure only elevates the standard. And she has defenses even under negligence. At least as to some of it. She has defenses under negligence. Plus, some of it's just straight opinion. Not all of it for sure, but some of it's straight opinion. So yeah, Flying Mom gives $20. Thank you very much. That's very kind of you. I have really no intention of doing the State of the Union. I don't see any value in it tonight, personally. But I might do a recap at some point. All right, so now that we've decided that we are going to not give default, which fair enough, the thing that's going to be the most helpful in that analysis is that the defense counsel had some sort of family emergency in there. So, fair. All right, for the temporary injunction. Temporary injunctions are governed by the rule of civil procedure. The relevant rule provides that no temporary injunction shall be granted without notice of motion or an order to show cause to the adverse party. Temporary injunction may be granted if by affidavit, deposition, testimony, or oral testimony it appears as sufficient grounds. Before or after commencement of a hearing, the court may order a trial on actions of merits to be advanced and consolidated. Even when this consolidation is not ordered, any evidence received upon motion for temporary injunction, which would be admissible at trial on merit, becomes part of the trial record, so it need not be repeated at trial. This provision shall be construed and applied to preserve rights the parties may have to trial by jury. Fine. In order for a temporary injunction to be granted, the proponent must show that other legal remedies are inadequate and injunctions necessary to avoid irreparable harm. Irreparable harm is the big one, for sure. If you have some other remedy, then do that, right? Irreparable harm is a big one. The irreparable harm must be established by verified affidavits or pleadings. Temporary injunctions are meant to preserve the status quo pending adjudication. Because applicant is asking the court preserve status quo until trial, the applicant must have a valid underlying cause of action to proceed to trial. The failure to show irreparable harm is sufficient. It sure is. If it's reparable harm, then the court can repair it. If it's only if it's irreparable, right? If it's repairable, which usually means money, yay money, then, wait for that to happen. If irreparable, then, we'll talk. When determining whether to grant a temporary restraining order or temporary injunction, the court considers the nature of the background's parties' relationship before dispute, the relative harms of parties if relief is granted or denied, likelihood of success, public interest, and administrative burden. If this sounds familiar, this is basically because it's the same standard everywhere. It's the 4-part standard. We know it. We love it. It's written slightly differently here in Minnesota as a slightly revised 5-part standard. But it's just the 4-part standard in a different shirt. It's the same thing. Plaintiffs argue that defendants posting on social media concerning plaintiffs and their associate entities can constitute irreparable harm. A loss of business and consumer goodwill can constitute irreparable harm. Plaintiffs allege the defendant's posting has resulted in a loss of business contracts and other valuable payments, particularly a contract to provide entertainment and online influence with Los Angeles Clippers and NBA team. She did seem to, let's say, interject herself into the contract between the Clippers and the 7M, arguably, possibly, some evidence along those lines, at least as it seems based on the pleadings. Again, that isn't to say that she did anything wrong. She may have defenses, but there's a prima facie case to be had. Defendants do not seriously contest the plaintiff suffered irreparable harm based on defendant's social media postings, only arguing the conduct is not itself defamatory. Okay, which it very well may not be. Addressing the first factor, the nature and background of the relationship is concerned with maintaining status quo pending decision. Prior to dispute, neither party alleges a relationship existed. Nope, they certainly don't. Plaintiffs were engaged in business in the state of California, and defendants were running their social media pages covering celebrity and entertainment news and gossip. The court finds this, therefore, to be neutral. There's no prior relationship to maintain. The balance of harms is the most important factor in determining whether injunctions should be issued. Plaintiffs argue they're suffering irreparable harm as a result of defendants' social media posts, and that any harm to defendants being ordered to not post is minimal. Well, it is literally ordering restraint of speech, so there's that. As discussed above, defendants do not seriously contest that there's irreparable harm. However, an injunction in the form plaintiffs are seeking would constitute prior restraint. Yeah. Furthermore, defendants argue they are far from alone in posting the sort of objectionable conduct about plaintiffs, which plaintiffs allege is defamatory. Many other media outlets have covered plaintiffs in negative light. The court finds the balance of harms, the injury to plaintiffs from defendants' social media postings, as compared to prior restraint weighs heavily against the injunction. Fair enough. I mean, freedom of speech is freedom of speech. And ordering people to shut up before full adjudication is a bit of a problem. And Katie Joy Paulson is at least partially correct, although perhaps not fully correct, that other outlets, including some notable outlets, have said some things that are critical of 7M and or Shin. The degree to which those things have been critical is perhaps not a one-to-one overlap with Katie Joy. But then again, Katie Joy doesn't need it to be completely one-to-one, and it would perform to the extent she was aware of it before she said what she said. It would go a lot to her mental state. If a reputable news outlet is reporting on it, then that increases her ability to rely on it. So, could be. With respect to the third factor, the likelihood of success on the merits, it's an error to grant temporary injunctive relief if a proponent cannot show any likelihood of prevailing. As discussed above, plaintiffs almost certainly must prove defendant acted with actual malice. And defendants can likely also avail of qualified privilege against defamation based on journalistic endeavors. If actual malice is actually the right legal standard, then 7M's job got a lot harder. Although it's possible that some and not all of them are public figures, because public figure status would have to be analyzed for each of them individually. Right? 7M is an entity. Shin is an entity. The other people that are mentioned are entities. Their public figure status or not, for each of them individually, must be assessed with respect to the statements that concern them. And I don't know that I can agree that all those entities are public figures within the meaning of the law, at least based on my assessment of things. Again, the court so far is doing absolutely no analysis of any kind to justify this conclusion. So I'm at a slight loss and disadvantage because the court may very well be right. I'm open to the possibility the court could be right. At the moment, I disagree with the court, and I'd like to know a little bit more about why I disagree with the court. Like, what is our point of disagreement? Because I've sort of done the analysis in my head, and I have my analysis, but I have no analysis from the court to compare and contrast. And so I'm in this position where I simply say, well, I disagree with your end conclusion, but I don't know how you got there. And maybe if you explain it to me like I'm a simpleton, I will understand. And I'll be like, you were right the whole time, court. How silly of me. But they're not doing that. And so I'm like, okay. No. Yeah. Plaintiffs have a steep mountain to climb while bearing a heavy burden to prove defamatory claims against defendant. And while the record submitted to the court at present juncture does not categorically show plaintiffs do not have any likelihood of success, the court does not consider the claim to have a substantial likelihood of being proven. Okay. Wow. That's a pretty bold statement. They don't have a substantial likelihood of being proven. So basically the court just said in so many words, if we're going to analyze this based on a percentage calculation, like what percentage do you need, right? You need 51% to win. You need 51% to win. So the question is, how much do you need basically at the start? How much do you need at square zero? How much likelihood do you need to win? And the answer to that question is what do you need for the prima facie case? And so this is analogous, although it's not the same, but it's analogous to a probable cause in criminal law, which you may be a little bit more familiar with, right? How much do you need to make the prima facie case? If we're talking criminal law and we're talking probable cause, not much, right? Probable cause in a criminal context is probably something like 30%. In a civil case, for like the bare bones pleading, 10%, right? So you have to like have a 10% chance of winning at the start, just to get past go. Or maybe, yeah, something like that. Maybe it's 5, maybe it's 10%, something like that. But in injunctions, one of the things you ask is there a substantial likelihood? Now, we know substantial likelihood isn't 51%, because if you have 51%, you've just won, right? It's not 51% because you've just won. Game over, right? So we know it's less than 51%, and we know that it's more than 10%, right? So what is substantial likelihood? Maybe 30%, something like that. So the court right now is basically saying in so many words, I am forecasting that Katie Joy Paulson is going to win this with 70% confidence. That's basically what the court just said in so many words. So Katie Joy Paulson has to be a very, very happy person today. She's got to be thrilled, because the court just said, I think their case is a loser. They've met their bare minimum technical requirements, but I think their case is a loser. And I think it's at least a 70% loser, if not more than that. I'm honestly not sure that I agree with the court's assessment on that aspect. The court's conclusions here are conclusory. So again, they're just kind of saying it. They're just saying this. They're not providing a rationale. They're not saying, here is how I got there. So again, I'm in this weird space where I'm assessing my own assessment of the case based on my thought process and sort of my own train of reasoning. But I don't have the court's train of reasoning. I just have their train of thought. And the court says, I think that Katie Joy Paulson is going to win with at least 70% confidence. And I'm over here like, really? You do? I'm not sure I agree with that, but I'm not sure why I don't agree with that. And I'm not sure if you're right. I wish I had more. In any event, Katie Joy Paulson's got to be really happy because things are looking really up for her. So, what can you say other than things are going really, really positive for her? So I suppose all the people that were looking forward to Katie Joy Paulson burning down to the ground, well, your joy may have been somewhat curtailed because the court doesn't seem like they're going that way. Okay. All right, fine. The fourth factor concerns public policy and interest in the subject of dispute. To do so, the court must ascertain whether there's been legislative expressions which manifest public policy. In this matter, concerning alleged defamatory statements or request to enjoin defendant from speaking, public policy is clear and not so much. We don't need a lot of discussion of what is the policy for restricting freedom of speech. We don't need a lot of discussion on that one. Why society has a pervasive and strong interest in preventing and redressing attacks upon reputation. An action for damages is the only hope for vindication or redress the law gives to a man whose reputation has been falsely dishonored. To impose prior restraint on defendant's speech in interim, however, is clearly against public policy. Fair enough. Finally, the administrative burden is high. Also fair enough. Okay. Well, I don't necessarily disagree with the court's end conclusion. I disagree with parts of its analysis. This is somewhat similar to what we were doing before. Like where I was saying, okay, the court is providing a rationale for why I'm not defaulting this case. And as to this piece of it, I don't know that I agree with the court, but I don't need to. Because even if I substitute what I think is true, I still get to the same place at the end of the page. So it's a disagreement that doesn't manifest in an ultimate difference. Similarly, as to the injunction, I think I agree with the court for the most part. I'm a free speech guy. I believe in freedom of speech. I believe freedom of speech is good. I believe people should have their freedom of speech and their First Amendment rights. If you don't like Katie Joy Paulson, not watching her is always an option. or you can exercise freedom of speech of your own to disagree with her in her opinions, preferably less with the personal attacks because it doesn't really help anybody in the end. But, she can exercise her freedom of speech. You can exercise your freedom of speech. Everyone gets freedom of speech. It's all good. So I think that I agree with the court's ultimate conclusion, while I question the part of their analysis where they're basically saying in so many words, I think Katie Joy Paulson, I think these are public figures, almost certainly public figures. Like, really? I think Katie Joy Paulson has a 70% chance of winning minimum. Really? I don't know. I don't know about that. I mean, I don't know that I need to agree with that to get to the same place on the end of the page, because the public policy reasons are so strong. I don't necessarily need to agree with those to get to the same endpoint, but damn. Me and the court are looking at this a little differently, so I'm not sure what that's all about, but okay. All right, let's go for the protective order. Plaintiffs seek a protective order with the following terms. All responses to interrogatories, document requests, and requests for admission shall be viewed at counsel for plaintiff's office in this address. Counsel for defendant shall be the only ones allowed to view, discover, and take notes. Cell phones and other recording devices shall not be permitted. This is sometimes called attorney's eyes only. It is not unheard of. It's a little unheard of if you're not going to allow the other lawyer to take notes or whatever. That's unheard of, right? Give me discovery under seal, so it's only for my eyes as an attorney. Make me come to your office and I don't even get to take notes. Seems like a little much. All depositions and resulting transcripts shall be confidential, and the contents thereof shall not be disclosed to anyone other than the parties in the matter in counsel. The rule with respective orders are as follows. We'll read this. Upon motion by party or person from whom discovery is sought and for good cause, the court in which action is pending, the court in which jurisdiction for depositions be taken may make any order which justice requires to protect a person or persons from annoyance, embarrassment, opposition, or undue burden, including one or more following. That discovery not be done at all. Discovery only be had in some limited respects, including designation of time or location or expenses. Discovery can only be done by one method rather than a different method. For example, interrogatories instead of depositions, or vice versa, I suppose. That certain matters not be inquired into or scope of discovery be limited. That discovery be conducted with no one present except persons designated by court. That deposition after being sealed be open only by order of the court. Trade secret not be disclosed. That one is extremely common. That one is all the common. If you have trade secrets, you're definitely going to get a protective order for sure. That parties simultaneously file specified document. Well, I say for sure, but you know what I meant. Nothing is for sure in law. Almost certainly. The parties simultaneously file specified documents in sealed envelopes. If the motion for protective order is denied, the court may order that any person provide or permit discovery. So basically, the court gets to manage discovery if it feels warranted. When seeking protective order, the moving party has the burden to provide a proving that justice requires. When seeking a protective order, the moving party has the burden of proving that justice requires the granting of protective order, because if discovery sought is permitted, the moving party will suffer annoyance, embarrassment, oppression, or undue burden. In applying the rule, the Minnesota Supreme Court has stated, although courts must be alert to protect parties and witnesses from unreasonable annoyance, expense, embarrassment, or opposition, they must be equally alert to see that these protective safeguards are not enforced in such a blind and sweeping manner that they unnecessarily become vehicles for suppression of evidence. In this matter, the protective order sought by plaintiff is wildly overbroad. It seeks to limit plaintiff's preponderance of discovery to counsel's office, with defendants themselves not be permitted to see discovery at all, and defense counsel not make copies. I told you that seemed like a lot. Such a limitation would cripple defense ability to defend their interests and become a vehicle for suppression. Although the suggested terms are clearly overbroad, the concerns over disclosing confidential information wholesale to defendants have some merit. Based on defendants' prior history of posting litigation material involving plaintiffs in other legal matters, it is reasonable for plaintiffs to fear that should they turn over sensitive information, defendants will post the same on social media. Accordingly, court will enter a narrower protective order in a separate order which will permit plaintiffs to designate certain discovery as limited defendants counsel eyes only and cover disclosures with prohibition outside litigation. Yeah, that's way more common. That is way more common. Come to my office and review it and you don't get to take notes sounds like some real bullshit. We'll disclose it to you, but under attorney's eyes only, and you keep it under seal in your office. Yeah, that's way more common. So 7M shot the moon on that one. That was not going to happen. I'm glad it didn't. That would have to be some really sensitive material. It would have to be, I don't know, the formula for Coca-Cola or something. I don't know what it would have to be to justify that kind of protective order. The rules of general practice provide a scheduling order pursuant to rule may be amended at pre-trial conference or upon motion for good cause. Except in unusual circumstances, a motion to extend deadline under scheduling order shall be made before expiration of the deadline. In this matter, a scheduling order was issued by a different judge. Plaintiff's motion for amended scheduling order for discovery, which stated in the scheduling order as of August the 5th, while plaintiffs filed their motion seeking amendment on August the 26th. The court finds circumstances justify the motion despite not being filed until after discovery order because the court was unavailable for scheduling conference. Fair enough. Motion to compel discovery. It's premature because we just moved all the deadlines, so we can skip that. So that's fine. All right. So overall thoughts. Overall thoughts is it's a good day. It's a good day for Katie Joy Paulson. It is a good day for Katie Joy Paulson. Things are looking up for her in her lawsuit against 7M. Given the statements that she made as detailed in 7M's complaint, many of which were quite aggressive in my view, I am somewhat surprised by some of the court's rationale and its arguments. I don't necessarily need to agree with those portions of the court's arguments in order to come to the court's conclusions. So my disagreements are perhaps slightly more academic than material in some respects, because I think the injunction makes sense, although I quibble with one of the factors in terms of likelihood of success. And I think that the giving the extension for various things because of issues, although I disagree with public figure status, is quite rational. And also very common in the respects that we've been talking about. I only wish that we had a little bit more on the court's rationale for why it thinks that the public figure thing is such a apparent lock, and why the court feels that, you know, that Katie Joy is going to win with such a surprising level of confidence. I mean, I probably would have just said, you know, I probably would have said that 7N has a substantial likelihood of winning, but public policy reasons, and therefore no. So I would have gone to the same place for other reasons, but it is what it is. So congratulations, Katie Joy Paulson, I suppose, congratulations are due to you, since my analysis seemed to not jive with the court's analysis. So good job. I'm glad things worked out for you, at least on a personal level. You know, things are looking up. So good, excellent. We can read this protective order as well, or at least glance at it. Any party may designate documents as confidential. Highly confidential attorney's eyes only means as limited confidential information that constitutes information producing party deems especially sensitive and limited to private financial information, sensitive and private business information, medical records, and personal contact information. Shall be limited to counsel of record only and cannot be distributed to clients, parties, or other individuals. This is not unheard of. All confidential and highly confidential information shall be used solely for the purposes of action, and no person shall directly or indirectly use, transfer, disclose, or communicate the information to any party other than specified. Any other use is prohibited. So you can't use what you learn in the discovery process except as is relevant in the court action. And depending on what happens in the court action, some of that information might get exposed, but that's part of the process, right? Until that happens, as part of the court process, it has to remain confidential. Access to confidential information shall be limited to court and staff, attorneys for parties, law firms, and outside vendors who agree to be bound. Persons shown on the face of the document have authority to receive it. Court reporters retained to transcribe parties, the parties themselves, outside independent persons who are retained by party attorneys to provide assistance as mock jurors or focus groups, or to furnish technical or expert service. All or portion of a document and information disclosed in deposition by witness may be designated as confidential information and thereby obtain protections according to confidential information. Any party who inadvertently fails to identify documents and information as confidential shall provide written notice. Any party receiving such notice shall retrieve documents from persons not entitled to receive them, shall return or destroy the disclosure of documents and information under this paragraph to persons not having authority under this order to receive them shall not constitute a violation of protective order if they're retrieved. Any party may request a change in designation of any information designated this way. So if you disagree with that, you can go to court and fight about that. Any such information shall be treated as originally designated until the change is complete. If requested change is not agreed to, the party seeking change shall within 30 days move to the court for appropriate relief. The party asserting the material is confidential or highly confidential has the burden of proving it. Within 60 days of termination of this action, including appeal or by way of settlement, each party shall destroy or return copies of parties all documents containing information designated as confidential or highly confidential, and all copies, and shall destroy notes, compilation, or data files. Each party shall provide certification. However, attorneys are entitled to retain a set of all documents filed with the court and all correspondence generated in connection with the action, which makes sense. Any party may apply for modification of the order. No action taken shall be construed as waiver of any claim or defense. The obligations survive termination of the action. Okay, that seems pretty reasonable. That seems pretty reasonable, all things considered. So while, again, I disagree with the court in part, I think the court's overall orders are probably correct and in keeping with legal jurisprudence. And I suppose we're going to go fight about it, and things are looking a little bit more promising for Katie Joy than they were before today. So, you know, she has cause to celebrate. She has cause to celebrate. So, you know, good stuff. You think this judge needs to go, Azaria? I don't know the answer to that question. I wish I had more to explain the judge's rationale. I want to have a fuller explanation of the rationale. You know, when I disagree, when I really truly disagree, for example, with, say, the Supreme Court, it's because I've had an opportunity to really read their full opinion, and I've had an opportunity to really consider their full rationales, and found them either agreed with or wanting. So I wish I had more to base my opinion on. Like, for example, in the Alex Murdaugh case, I have more because the judge has explained the rationale from the bench, and I find the judge's order overly broad, in my view, in a way that, in my view, is probably legal error. But I can only reach that conclusion because the judge has provided a full explanation from the bench as to their legal rationale, whereas this judge has not. And so I don't feel confident enough in my own opinion without their opinion to counter. Like, I have not gone through it in such a level of detail or such a level of analysis that I'm like, there's just no way for the court to get there. I'm not ready to form that kind of opinion. So I want to give a more cautious opinion. It's like, I don't quite agree with this. I'm not quite sure it's true. I'm not quite sure it's true with respect to all the parties. I'm not quite sure how they're getting there, but without me having either really exhaustively considered all the issues, so I'm like, no, my opinion must be correct, or having the court's opinion to read off of, I'm not going to sit here and just disagree with them for the hell of it. The court might be right. I just wish I knew more so I could be like, how much do I think the court is right or not? Or where do I disagree with them or not? It's like, I don't have enough. I don't have enough. Shirori asks, are politics and law the same thing? Not to my mind, no. Would I consider all lawyers politicians? No. Do lawyers uphold the law? Hopefully. Are these positions separate in their respective place within the whole law? Yes. Politics is primarily about policy. Law is not about policy. Policy is done by the policymakers. Law is about application of that policy. So, to my mind, they are distinct. You think this is a first for me? In which respect? Spiritual healer. I do this kind of thing all the time. At least in my own mind, I do. I don't know what you think is a first for me. I feel like I am often. I don't feel like what I'm saying is manifestly different than what I'm used to saying. Where I have stronger opinions, it's where I've thought about it a lot more. Usually, I think you have a more firm opinion one way or another. Well, in a lot of those situations, it's because I've been thinking about it a lot longer. Like, or thinking about it in a lot more detail. If you're thinking about like constitutional law cases, I tend to think about those in a lot of detail and for a long period of time. Like one of the reasons I have the views I do on a lot of constitutional law questions is because, well, I've been thinking about them for a long time and I've really thought them through and feel like I have a pretty solid opinion. So, yeah. But this is, I don't, yeah, that's sort of how I think about it. I don't think I don't know that the issue is that the court is biased. I'm not sure I agree with that conclusion. And even where I disagree with courts, I tend to not think it's bias. I tend to think it's just because we have different philosophies. I don't often think that judges, I don't often come to the conclusion that judges disagree with me because of bias. It's just because we assess things in different ways. We think about things in different ways. I don't think it's a win for KJ's eagerness in terms of discovery. Does the PO mean that she'll no longer be showing them over the case? No, she's allowed to talk about the case. She just can't talk about anything that she would learn from the case itself. She can talk about the parties. She's not precluded from talking about 7M. She's not precluded from sharing her opinion. She's just precluded from, in so many words, using anything that she would find in discovery going forward. So she can still talk about things that she would learn or know from outside that process. So that's fine. Do I still have my books and notes from law school? No, I still have my notes probably floating around somewhere in my hard drive. My books I sold off a long time ago. There was really no reason for me to keep them. Books in law school are just like compilations of case law anyway. So they're just really compilations of cases. And if I want to look up a case, I just look up a case. Anything else? There doesn't seem to be any more questions right now. Thank you for the $20 worth of super chat. I really do appreciate it. I really appreciate all your guys' continuing support as always. All right, I'm going to go ahead and end the stream. Only attorneys can view things 7M's mark as confidential. The things they mark as highly confidential. Katie Joy can see the things marked as confidential. She can see the things marked as confidential. She can't see the things marked as highly confidential. The judge split that nuance. Do I deadlift? No, I have deadlifted in the past. I don't deadlift right now, because I'm sort of working my way up to more freeform exercises. So, for example, when I do squats, I use a squat machine rather than freeform squats. Um, I do. I don't do a straight. I don't do a straight barbell deadlift right now. For example, I do cable equivalents and things like that right now. Eventually, I will do um, deadlifts with barbells, but I'm not doing that right now. Can I give an example of what would be considered highly confidential? I can do better than that. The court told us exactly what it is. I can just go back to the text. Highly confidential means and is limited to confidential information that constitutes information the producing party deems especially sensitive and is limited to private financial information, sensitive and private business information, medical records, and personal contact information. Those would be all the things that is. Jules gives $4.99, says, much love, Kurt. Glad to see you on Rakita Day. Your channel's my favorite for law things. Oh, that's really nice. Thank you. All right, I'm going to end the stream and I'm going to dump you guys over into Nally, the lawyer chick stream. So make sure to give her a little uncivil law raid love and when you show up and to let her know that we're there. Give her a little uncivil law how do you do and maybe a little cowboy hat action, uncivil law raid. Dumping you over into Nally, the lawyer chicks chat. I'll see you guys over there. Maybe I'll pop on the stream, maybe not. I might just watch. It might be fun. In any case, I hope all is well. Let me make sure I actually set that up properly before I end the stream. I did. Great. I've been on civil law. Until later, my friends. I hope all is well. Cheers, my friends, and goodbye.